Hello, everyone. Welcome. Thank you so much for joining us for this wonderful event that we have been prepping for a while now. My name is Gabriela Zanfir Fortuna. I'm a director for global privacy at the Future of Privacy Forum, a think tank based in Washington, D.C., with offices in Brussels and Tel Aviv for the time being. But who knows what the future brings, right? And maybe we'll be in Brazil one day on the ground. And Bruno is our co-host for the day. Bruno?
Yes, thank you, Gabriela. I really enjoyed the possibility of having you here in Brazil. I can confess. So we are delighted to have to co-host this event with Gabriela and our friends from Future Privacy Forum. As Gabriela just mentioned, we were preparing this event for a while, and now we are having here we have here a stellar team to discuss a legitimate interest from US, EU, and also Brazilian perspective.
Indeed. We are launching today the English translation of a very good report that Bruno and two co-authors published for Data Privacy Brazil on the topic of legitimate interests under the LGPD. They have use cases, very much a detailed analysis of use cases, and they have a theoretical framework of relying on legitimate interest as a lawful ground for processing personal data under the LGPD. We will be discussing the report. We will be discussing this lawful ground in general from a comparative law perspective, primarily from the GDPR point of view, but we will bring in some of the experience from the US as well. And to kick things off, Bruno will introduce our keynote speaker for the day.
Yes, we are delighted to have Miriam Wimmer, which is one of the directors of the Brazilian National Data Protection Authority. But I can also say that Miriam is one of our greatest specialists in internet governance, AI, and of course, data protection. She is working and dealing with those issues since he was appointed at one of at the Secretariat of the Minister of Science and Technology. So Miriam, I'm glad to have you here. We are glad to have you here. And thank you so much for finding a space and a time at your so busy agenda for us.
Thank you very much, Bruno and Gabriela, for your kind introduction. And thank you for inviting me to this wonderful panel with these great speakers. I feel truly honored to be invited to provide some opening remarks to kick off the discussion on legitimate interest as a lawful basis for data processing. So I have some PowerPoint slides here. I'm going to briefly share my screen. Let me see if it works here. Okay. Could you please let me know if you can see my screen? Yes? Okay, yes. Wonderful. So discussing legitimate interests in Brazil is very challenging because, in fact, our law is fairly new and all of these legal bases still have to be further explored. But I think that when we look at, the international experience and when we look at literature on data protection in general, it's very common for us to see discussions on legitimate interests represented through metaphors related to some sort of balancing. So either we have balances or we have people walking on tightropes, and always there is this general idea that we are placing weight on different aspects that need to be protected, be they the legitimate interests of a business organization or be they the legitimate expectations and rights of data subjects. And I think that, of course, discussing legitimate interests as a lawful basis for data processing is particularly important as we see that there has been a shift away from the idea that consent is the only manner in which we have to provide for informational self-determination. So in Brazil, just like in Europe and in other countries, we have this idea of personal data protection and privacy associated to fundamental human rights and connected to the idea of informational self-determination, the ability to control and to have influence over the manner in which our personal data is processed and handled in the public sphere. And the legal basis of legitimate interest somehow creates a kind of tension because in this case, we are assuming that it is legitimate to handle data not based on the consent or on the interests directly of the data subject, but also on legitimate interests that are associated to usually the business entity that is aiming to handle data. And this is, of course, a discussion that is very mature and very well developed in Europe. And I note that in the 1995 directive and also in the GDPR, we have a very clear statement that processing is lawful if it's necessary for the purposes of the legitimate interest pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, in particular where this data subject is in a more vulnerable position, for example, a child. And this is a discussion that has been going on for a long time. And when we look at the GDPR, we realize that there is already a certain level of maturity in terms of understanding what is actually admissible under legitimate interest. So usually there's this idea of balancing or contrasting these different interests and making sure that the interests of the controller do not override the interests of the data subject. And then there are several other elements that are usually put on the table in order to allow us to assess if in fact these legitimate interests are sufficient to entail the data processing. So usually there is mention to the reasonable expectations of the data subject and the idea that the data subject should be able to reasonably foresee this specific use of data. The idea that legitimate interests make sense when there is already a relationship between the individual and the controller. And then the GDPR goes forward and provides for several examples in which the basis of legitimate interest seems to be appropriate. For instance, direct marketing, transferring data within a group of undertakings, information network security, and prevention of fraud. So all of these examples are, I think, very illustrative in terms of showing that consent will not always be a feasible legal basis, but the processing is in fact legitimate because it attends not only to the legitimate interests of the business organization or the data controller, but it also does not excessively violate or harm in any manner the interests and fundamental rights of the data subject. And in fact, looking at this issue in Europe, we have seen some decisions already by the European Court of Justice. There was the famous Riga decision, and then more recently a decision in Romania concerning the use of CCTV. And what we can see in these judgments and these decisions by the European Court of Justice is usually the idea that legitimate interest requires a test, a three-part test. I know Bruno will say that a four-part test will be more appropriate, but let's take a three-part test for now to start with, which requires the data controller to ask, is there a legitimate interest? Is this interest lawful? Is it ethical? And then, is the processing necessary for that purpose? Are there perhaps other means to achieve the purpose which would be less intrusive? Are there other legal bases which would be more appropriate? And finally, the balancing test, which requires controllers to evaluate if the individual's interests would override the legitimate interest of the data controller. And then in this balancing test, usually it is included also the idea of establishing appropriate safeguards, for instance, anonymization, pseudonymization, cryptography, or also the possibility of opting out, of objecting to that particular data processing operation. And having said that, I think it's important to take a look at what's going on in Brazil. And I think a starting point for this discussion is necessarily the recognition that our Brazilian legal framework is very strongly influenced by the European approach. And this is, I think, fairly easy to see. We have, a number of minor differences, I would say, between LGPD and GDPR, but the approach in general is very similar in the sense that we have also the idea of a fundamental human right. We have an ex ante approach, which requires data controllers and data processors to identify a legal base which makes it lawful for them to process data. We also have a number of principles which are very similar to those contained in other international documents, for instance, in the OECD guidelines on privacy and cross-border data flows, and also in the GDPR. And we have a number of rights that are attributed to the data subject in order to allow him or her to, in fact, exercise their self-determination in terms of how their data flows around the world. And also in Brazil, as in Europe, as in other jurisdictions, there is the firm idea that the purpose of these laws is not to restrict data flows, but to enable them to flow while maintaining a high level of protection for data subjects. So having said that, when we look at how LGPD was discussed here in Brazil, I think also an important note of context is that this is still a fairly recent discussion here in our country. In fact, I'm aware that in Europe since the 1970s, there are countries that have data protection laws, and this is a scenario that contrasts very strongly with what we have in Brazil. In Brazil, the first public discussions on having a general data protection law began in 2009 or 2010 when we had the first public consultations. Then over the following 5 years, the discussions were held essentially within government. So the Ministry of Justice, who was coordinating this discussion at the time, went through several rounds of debates with different governmental stakeholders, also with some private stakeholders. And then in 2015, we finally had a second public consultation on the draft bill of law that would in the future become the LGPD. Of course, it's important to note that this second public consultation, 2015, was also, in a sense, incentivized by the Snowden revelations in 2013 and the approval in Brazil of the Marco Civil da Internet, our internet's civil rights-based framework for the internet, which was approved in 2014 and also had some very preliminary and very basic rules concerning data protection. In 2016, our draft bill of law was sent to Congress, and then we had a very interesting dispute between competing versions of the law. So there were already some bills in discussion, then this draft bill was introduced, and finally in 2018, in August 2018, LGPD was approved and signed into law by the former president, Michel Temer. Then we had other legislative discussions. We had a provisional measure. We had discussions on postponing the entry into force of the LGPD. But finally, last year in September, our law entered into force. And a few months later, in November, our National Data Protection Authority, ANPD, was finally created. The reason I'm bringing this discussion is to say that although it took us 10 years to approve our law and to create a national DPA, this is still nothing when you compare it to the experience of Europe and other countries, because in fact there is a great lack of judicial decisions, of administrative procedures, of understanding, of studying this legislation. And during these 10 years, I think it's fair to say that a quite restricted group of experts was involved in the discussion, and that only from 2018 forward did we gradually see the broadening of this discussion to a wider group of stakeholders in academia and civil society, and also within the business community. And when we look at the LGPD today, we see that in fact there is the provision that states that data processing can be done under legitimate interests of the controller or of third parties. But in fact, we have 10 different legal grounds which enable data to be processed legitimately. And there is still a certain lack of understanding, of discussion of what each of these legal grounds in fact entails. So our law, for instance, says that consent has to be unequivocal, has to be explicit, has to be free, but we still do not have guidance from ANPD or from other public bodies on what in fact free consent means. And I think the same applies to when we discuss legitimate interests, because although this was a very heated discussion while the law went through Congress, there is still a need for more guidance, for more clarification on in which cases legitimate interest is in fact an appropriate legal basis. I recall also that legitimate interest was not a legal ground that was initially proposed for our LGPD. So when the first proposals came forward, there was no provision of legitimate interests. And this was introduced further on during our legislative debates. And I remember also very clearly that maybe the first general reaction was, well, now we have a carte blanche, now we have a blank check, and anyone can just say they have a legitimate interest to process data, and that will be okay. And this, of course, raised a huge discussion. And also, I recall that in 2017, while our draft bill was still going through Congress, I was able to organize a very large workshop, which Bruno was in fact a part of. If you look at the bottom right corner of the picture, you will see Bruno there in the background. And one of the points of discussion was, in fact, how do we make sure that legitimate interests are used appropriately? How do we make sure that this is not a super flexible legal ground that will allow for any kind of data processing, even if this represents a violation of the expectations or of the rights or of the freedoms of the data subjects? And I think that as the law went through Congress, it was possible to increase our understanding of this legal ground. And in fact, when we look at the law today, we can, first of all, very clearly see that there is this idea of balancing, of the idea that the legitimate interests of the controller or third parties have to be somehow balanced or compared with the data subject's fundamental rights and liberties. And also the law went even further and provided for an entire article that creates, I think, a better standpoint, a better background for us to interpret this legal basis. So if we look at Article 10 of LGPD, for instance, we have the idea that these purposes need to be legitimate, they need to be based on concrete situations. Then also the idea that processing should be restricted to the personal data which is strictly necessary for the intended purposes. We have the idea that here there is an increased requirement of transparency when data is processed based on legitimate interests of the controller. And finally, we have here the provision that the national authority, our ANPD, may request a data protection impact assessment when data processing is carried out based on legitimate interests. So we have here a number of provisions, and I think in a very simple manner, it's easy to understand that here we have two different issues which need to be compared: the idea of legitimate interests related to legitimate purposes, concrete situations, and on the other hand, the idea of fundamental rights and freedoms, on the idea of legitimate expectations, of treating only strictly necessary data, providing transparency, and I would add also other safeguards, and this is something that the report that was mentioned earlier very clearly states. So we currently have a discussion in Brazil as to what steps should be taken if a data controller wishes to process data based on legitimate interests. And there is currently an interesting discussion if it would be necessary to carry out a data protection impact assessment in all cases, or if it would be admissible to carry out a legitimate interest assessment, which is, I think, a simpler mechanism of verifying if these competing values are in fact appropriately considered. This is something ANPD has not yet spoken about, but I think it is important to note that DPIAs are required when there is a significant risk related to data processing, and that many times data processing under legitimate interests will not necessarily entail a higher risk for fundamental rights and freedoms. So this is certainly something that needs to be taken into account. Another point I'd like to highlight is that when we look at LGPD and when we look at the 10 different legal grounds that our law provides for, there is in fact no hierarchy between these legal grounds, which means that all of them are equally important, and there is not, so to say, a preference for one legal ground over the other. And in this sense, I think that our approach is very similar to what was noted by Working Party 29 in its opinion issued in 2014 on legitimate interests, where the document notes, among many other relevant points, that legitimate interests should not be considered either as a last resort, which means, a legal ground that you would look to as an exception, as something that is used to fill in the gaps when we have a rare situation, an uncommon situation where other legal grounds would not apply. And it should also not be seen as a preferred option, as an option that I would naturally go to because it's between, commas, it's easier, so to say. In fact, when we look at legitimate interests in the LGPD, I think it's very clear that this is a legal ground that is applicable to certain circumstances, and that what data controllers have to do, in fact, is to evaluate in light of the concrete circumstances which legal ground is more appropriate. I think that we have a quite challenging situation in Brazil at this point because, in fact, our law is in force since last September. Administrative sanctions will be in force as of August this year. And in parallel, ANPD has only very recently been constituted. We have been in existence for only 6 months. And I think there are many, many fields in which there is an important and urgent need for greater clarification, for guidance, for further regulation. And in this sense, I would just briefly like to call attention to our regulatory agenda, which was approved early this year, I think in February, and to mention that some of our aims have already been fulfilled. So we have already concluded the approval of our internal rules of procedure, of our strategic plan. We have already initiated consultations on special rules for SMEs and also on the issue of data breaches and data breach notifications, and that we plan early next year to begin working on providing greater clarity through guidance or through regulation on these different legal bases for data processing. And I think it will certainly be very important for us to greater explore these different aspects of the law in terms of the necessity of transparency and also what kind of assessment is necessary when the data controller wishes to use legitimate interests as a ground for data processing. In this sense, I'd like to conclude by saying that the report that is being launched today, also in English, will certainly be a very important contribution to the discussions here in the country. I mentioned that I have read the report on several occasions. I have shared it with my colleagues at ANPD, and I think it is in fact a wonderful contribution to help us to better understand the conditions in which this important legal ground can be used here in Brazil in a manner that on one side recognizes that data needs to flow and needs to be used, but also that data subjects' rights need to be respected. So I'd like to close my comments at this point, and I very much look forward to hearing the other speakers. Thank you very much.
Thank you very much, Miriam. That was extraordinary. And it's really impressive to see how much attention is paid to details, to the history of this provision in European Union data protection law, where we see it indeed explored for many years now. And it's also extraordinary to see how much work has been done already by the ANPD and the clear path forward for the next 2 years at least, in terms of the regulatory agenda. We applaud the fact that you are so open, and I think a lot of the stakeholders will be interested to provide input, during public consultations. And this collaborative atmosphere around the implementation of the LGPD is really something extraordinary that we highly admire, I have to say. Thank you so much for the keynote, and it is my pleasure now to bring up on the virtual stage the panel of experts that will support the discussion today. So we will be joined today by 4 experts. You have already met Bruno, who is one of the co-authors of the report. Together with Bruno, we are also very honored and happy to have Lara Hoffman. Lara is based in the US, in California. She is the Vice President for Legal and the Data Protection Officer for Netflix, which is not an easy job. She has to look at 90 jurisdictions, at least the last time I looked about this information. Thank you so much, Lara, for joining us. We are also joined by Hilke Heijmans. Dr. Hilke Heijmans, he is the chairman of the litigation chamber of the Belgian Data Protection Commission. He is also a member of the board of directors of the Belgian Data Protection Commission. And he has been in either a regulatory role or a scholarly professorship role for many years in Europe, working on data protection law. Welcome, Hilke. Thank you so much for joining us, and especially at a late time for you. And then we are also very lucky to be joined by Marcela Matiuzzo, who is a partner with VMCA Associates, a law firm based in Brazil. Marcela practices in the areas of antitrust and data protection law. She has been following the process of adoption and then of implementation of the LGPD for a long time. Thank you so much, Marcela, for joining. And now I will start the conversation by inviting Bruno to tell us a bit about the report. What prompted you to write this report, Bruno? Why did you choose legitimate interest as the key topic? And then perhaps you can also tell us a bit about the structure just in a couple of minutes before we dive deeper into the conversation.
Thank you for the question, Gabriela. I'd like also to thank you for the panelists to be here today with us. So basically, the report is divided in two components. The first one describes the history behind of the drafting process of the legitimate interest as a lawful ground, and the second part of the report describes, or at least shows, some roots for the challenging interpretation of this specific legal base. I'm going to share a little bit of a presentation here that I have. I think it's going to be easier to move forward. Yeah. So what I'd like to share with you here today, and I also would like to highlight that the policy paper was co-authored with Mariana Rielli and also Marina Kitayama. It's the twofold goal, also to not only highlight how was the policymaking learning the path to craft these new legal grounds in Brazil, and also how the Brazilian civil society was able to finding a consensus on it, but mainly what is the normative structure, the normative design of the Brazilian data protection law to deal with legitimate interests as a legal basis. So the first goal and the first chapter, let's say, of the policy paper, the path to the legitimate interest as a legal ground. As Miriam just described, it was a long path, a long journey. At least we are discussing a comprehensive data protection law here in Brazil for almost a decade, 10 years of discussion, but legitimate interest as a legal ground just came out for the first time in 2015, so 5 years that the debate started. And since the beginning, there was a lot of debate and dispute behind of it, because as just Miriam Wimmer described, this legal base was viewed, or at least analyzed, mainly from the NGOs and the organization that deals with human rights, consumer protection, as a blank check or some room for abuses. So there was a kind of this pendular movement. On one hand, there was private sector lobbying in favor of adding this legal ground. On the other hand, NGOs lobbying against the inclusion of this legal base. And I can say that in the center of this pendular movement, there was the academia. Academia saying it's important to have this legal base, to have at least more a flexible regime to foster innovation, to foster data process as a good, data as a common good, and so on. But at least we have to set some parameters in order to deal with that specific legal base, which is tricky. So in that period, I can fairly say that the Brazilian civil society was much aware the debate that was ongoing on in Europe, and we took advantage of our regulatory delay. In which sense? Since the directive of 1905, there was no consistent and harmonized approach in Europe, because it was not easy to balance legitimate interests and legitimate expectations of data subjects. And taking into consideration, bearing in mind that kind of scenario, what we have discussed and what you have decided here as a Brazilian civil society was try to put in the text of the law some guidelines, some parameters to interpret such open and broad legal concept as a legitimate interest. And the final result of this discussion, that I can say like a common denominator or as a consensus, was to create a specific article, which is the Article 10 in LGPD, that set those kind of parameters in order to interpret and ultimately give some legal certainty about how this legal ground, this new legal ground, will be applied here in Brazil. And we talked about this history and this lobbying battle in our project, the memory of LGPD. It's very interesting to know, and I invite you to have a look on that. But what I think that is singular, and it's a particularity in this policy-making process, is the result. The result that right now we have here in Brazil a really singular normative design that put in the text of the law a scenario that legitimate interest is not only provided as a legal base, such as Article 7 and 9 provides, but also we decide to put a specific article, which is Article 10, that sets the requirements for application. And lastly, our law also reinforces the obligation of keeping data processing records when the data processing is relying on legitimate interest, as we call in this policy paper as a normative equation of LGPD. And what are the fruits of this normative equation? First of all, and I know that Marcela has a different position on that, but we do believe that taking into consideration this structure of Article 10, our legitimate interest assessment would be divided in 4 steps, because this corresponds, this mirrors exactly the structure of Article 10. The head of the article says some words and provides some parameters regarding the legitimacy and the legitimacy of the purpose, and says specifically that this legal base could not be speculative, should be based on a concrete situation. The paragraph 1 says specifically that we should put even more attention on the notion of minimization, which in our law is the combination between 3 principles: purpose limitation, adequacy, and necessity. And in the third phase or third step, we should consider the legitimate expectations and also the impact on the freedom and fundamental rights of data subject. And in the last part of this article, there are some, let's say, reinforcing. There is a reinforcing of specific safeguards, specifically measures of active transparency when data processing is relying on this specific legal ground. So, taking into consideration that specific normative design, our policy paper tries to set some roots for future interpretations on that. There is some controversy here in Brazil if when data controllers is using this specific legal ground, they should be necessary carried out data protection impact assessment. Why? Because Article 10, paragraph 3 says that the national authority may request a data protection impact assessment from the controller when the processing is based on legitimate interest. Our normative recommendation at the policy paper says no. Why? Because data protection impact assessment is a complex documentation, and what defines and what precise if there is a higher, medium, or a low risk of data process activity is not the legal ground, but let's say the profile of the operation at stake. You have to take into consideration if there is a sensitive data, a high volume, if it's going to use as an instrument for decision making, automated decision making process, and so on. That's why the so-called normative equation of LGPD is so important, because if you are going to combine the principles, Article 10, and specifically Article 37, that says about the obligations of keeping records of data processing, the result would be a different kind of documentation to render an account on that, which is precisely legitimate interest assessment. And the second issue that we would like to address, or at least to set some rules for interpretation, and that's why, because LGPD is not so detailed as it is GDPR, it's the limits and also the possibilities of legitimate interest as a legal base. Specifically, if is there or not a right to opt out when this legal base is being used. We know that GDPR has a specific provision that even says there is an absolute right when a legitimate interest is used, when a data processing activity is relying on legitimate interest for direct marketing or marketing purpose, but we don't have this here in Brazil. So there is a huge controversy if there is that kind of right, and how we could at least set some reasoning for that. And one thing that you should take into consideration, and the Brazilian law has also a specific normative design on that, it's the principle of good faith. And legitimate expectations is, let's say, a result of this of the application of this principle here in Brazil. And just to finalize, the last part of our policy paper is directed for decision makers, the DPOs of organization, and also for data protection authorities. We analyzed the legitimate interest in 10 sectors or 10 case studies, and from that we extracted a kind of a thermometer of the LIA, legitimate interest assessment, in the Brazilian way, Brazilian version. Then data protection authorities and DPO, when are using or relying data protection activities on that specific legal route, should pay attention or should pay at least more energy in specific components or specific steps for the legitimate interest assessments, and ultimately putting safeguards, managing the regulatory risks when this legal base is at stake. So is that for now, and I'd like to thank you, Gabriela, for the kind question, but difficult one.
Thank you so much, Bruno. This is groundbreaking work, actually, and I hope now everyone listening to us understands why we were so interested in seeing the English version of your work, and this is why FPF supported the translation of your work. I think you are asking essential questions, and questions that will ultimately have impact in practice. And speaking about practice and speaking about why legitimate interests as a lawful ground for processing personal data matters in practice, I will want to go to Lara now and ask her to share from her experience, because she has to implement, lawful grounds for processing for very, very complex processing operations. Why do you think a ground like legitimate interest is necessary in comprehensive data protection legislation like the GDPR and the LGPD? And what I mean by that is that these laws apply broadly to personal data defined, as we know, very broadly, and to processing operations defined very broadly. Lara.
Thanks, Gabriella, and thank you so much for inviting me to participate today. This is a wonderful panel, and I'm looking forward to learning from the other panelists as well. Just a quick note, I'm here speaking today on my personal behalf based on my broad experience in this field over the years. Nothing I say should be attributed to my current employer. But I also want to express great appreciation for Bruno and the team's work on this paper. I echo Miriam's point earlier. I think this is a wonderful contribution to a very, very important conversation. And Gabriella, I agree with you. I think having legitimate interest as a component of comprehensive data protection laws is very powerful, including for data subjects, and an important mechanism that we should be considering. Let's take a point that Miriam was making earlier about different legal bases for processing, and we shouldn't necessarily, as the Article 29 Working Party has said previously, look to legitimate interest as the first, nor do we have to look to it as the last, but you can look to it as a complement to other bases for processing. And I'll take contract and consent as examples. Depending on what it is you are doing with personal data, there can be spaces between contract and consent where legitimate interest can fill and fill in a very meaningful way. Miriam mentioned earlier fraud detection and prevention, systems security. Those are fairly obvious uses that you wouldn't want to leave up to consent, because the people who want to commit fraud are never going to consent to your ability to use their personal information, their personal data, to engage in fraud prevention. So legitimate interest fits in very nicely there. Another area would be employment data processing. In some cases, because of the relative power differential between the employer and the employee, consent may not necessarily be the appropriate legal basis to use, but legitimate interest could be. So when you think about things as simple as a company directory or even an ethics reporting hotline, those are great examples where legitimate interest can come into play. General corporate operations is another good example. Conducting audits, engaging in compliance with internal procedures. Those are areas where legitimate interest helps. Analytics is a key one for product and service improvement. One of the other reasons I like legitimate interest as part of the suite of legal bases that you can use is, I think in some ways it arguably demands more thoughtfulness of you as a controller than perhaps consent does, because with consent, you're really putting all of that onto the data subject. You have to be clear with the data subject. You have to be transparent. The notice they are given needs to be appropriate. Obviously, that's the responsibility of the data controller. But if I, as a data controller, am choosing to engage in legitimate interest as my legal basis, I have to take care. And I do like the way Bruno has broken it down in the paper with looking at legitimacy, looking at necessity, and then engaging in balancing. And you could think of safeguards as being part of that balancing, and you can also think of safeguards as being an important component in and of itself. And if I have to think through that process anytime I want to invoke legitimate interest, perhaps I'll be even a bit more thoughtful about, is this really the right legal basis? Is there another one I should be using? But it forces me in a good way to think about the data subject and what she, he, or they may need in terms of their considerations.
Thank you so much for those comments, Lara. And I will pass the microphone now to Hilke, because we've seen that the GDPR actually had a lot of influence over the content of the provisions in the LGPD. And then we've also seen that there are some differences, but we'll go into the differences perhaps later on. Hilke, my question for you is, what are you seeing in practice in Europe? We have had this lawful ground for processing for many years now, as Miriam was saying in the keynote. There have been a lot of misconceptions about relying on this lawful ground. Can you share with us from the European experience, what are some of the most common misconceptions controllers have about this lawful ground? And then also, what are you now seeing in practice after the GDPR became effective 3 years ago, because we are very close to the anniversary? Have controllers learned how to properly rely on it or not?
Thank you very much, Gabriella. It's always nice to see you to do this with FPF. I saw a nice book in back for your room, which is called A Passage to Europe, a book which I like a lot. One of the best books I think written about the European Union. And I also see that there's a lot of influence from the EU going to other countries of the world, especially in our area, especially in data protection. We see that with the data protection law of Brazil as well. On the other hand, when I listen to you, I don't think we are the ones teaching others. I think you, especially if I hear what Bruno has to say, Miriam, before, I think that we can also learn a lot from Brazil, from new things happening there. So this exchange is something which I really like. I'm also very happy to get to know a colleague from the Brazilian authority. I would say welcome to the club. It's this club of data protection authorities is an interesting club, is a nice club. We used to meet every year, physical. Last year we did it online. It was a quite different experience, I must say. It was very fruitful, but not at all nice. So I hope that this year can become better, and we hope to include Miriam there as well, I hope. So what I see as well is, and that's something we look a lot at from Europe, the idea of global convergence. Global convergence is really coming there in this area, and I think that's extremely important to talk about, to get to know. And I think we learn from each other. We will keep on learning for each other, because I think I heard also some interesting new things in the in the presentations I just heard. Let me go into the question was asked to me about misconceptions, etc., about legitimate interest. Well, I think we all have the same, so we all know them, but it's nevertheless nice to say something about it. One word I didn't hear yet until now, and it's the term fairness. Fairness is, if you look at the GDPR, if you look at the Charter of Fundamental Rights of the European Union, data processing is the core, the basis, what it all boils down to. And of course, fairness is a very general term. It's a very open term. So when we talk about fairness, we are legitimate interest is one of the elements, one of the ways of processing. Fairness, so. But what are the misconceptions? I think the most important misconception has already been mentioned in different ways, namely that consent is basically the basis of data protection, and there are some exceptions, legitimate interest being one of them. I think that's not the case, and I think it's also very well mentioned already, also in Brazil, but also in Europe. There's no hierarchy. It's not first you try consent, and if you cannot mention consent, then you can go to the next one. That's not true. There's no hierarchy. There's also the question, what protects better? The misconception that legitimate interest is not protective. That's a misconception, I think, but there is something true about it. When I hear specialists or privacy professionals like Lara, for instance, she tells us clearly that the way they implement it in her company, with really putting good guarantees at place and putting that everywhere. When I look at my daily work as supervisor, dealing also with local companies, dealing with companies which are not as far as Netflix, I think there is a reason to say why legitimate interest is not necessarily protective. But it's something we all have to learn, we have to develop, we have to. But that is the most important. That is an important misconception, nevertheless. The next thing is the misconception number 3, I would say, and that's a discussion we have here in Europe, whether or not purely commercial interest of a company can be a legitimate. That discussion is there from the beginning. It comes up every now and then. I think the most important question still has to be solved. I think we use a lot of elements of legitimate interest which are close to commercial interest, like for instance fraud protection or also direct marketing. But is a commercial interest as such, can that be a legitimate interest? I think it can be, but there are different views on this, and I think this is one of the most important and most difficult issue to be solved in the upcoming guidance by the European Data Protection Board. That upcoming guidance can be expected, we hope, still this year or a few months. And I'm not writing it, so I'm just telling what I. So those are a few elements what I would like to say. Then, of course, do you want to be concrete? I think many examples which we face in our daily life have already been mentioned, like, for instance, employer data, fraud control. I think helpful when you talk about legitimate interest in Europe is looking at recital 47 of the GDPR, talking about, and then I think the main important element is the expectation of all them everywhere, and exactly what it is. It's always the question: what can a data subject expect? And those questions, when we deal with cases with lawyers, they always come up with this question, and depending on the point of view, they talk about the expectation of the data subject, which is not so easy, I would say. There's a few more things I would like to say. I think the most important, but maybe that was the next question, development in the EU, I think in terms of legal scholarship is in fact given to us by the Court of Justice. There's a few cases which Miriam already mentioned, but this Rigas case and this Romanian case, which Gabriela I'm sure knows by heart, those cases are really, really helping us in giving us a 3-steps approach, which I can discuss, but I think that will, I don't want to talk too much at this moment. However, there are a few questions I start having. The link between DPIAs and legitimate interest, that's, I think we in Europe don't see that link so closely. We see the DPIAs are really for exceptional situations, are also not meant for actual processing, but they're meant as how to put your technical or organizational measures in place, how to ensure accountability. So when you have high risk processing, then you do a DPIA. But the link with legitimate interest, at least in our daily work, not a case. Another thing which I found interesting and which we don't have in our GDPR, strangely enough, we have it in our rules for the police, is the idea of obligations to keep logs of data. And I think there will be records of data processing operation. The records we have, let's say, logging what you do with data. And I think that's what I heard also from this Brazilian example. So that I found interesting to hear. That be having said that, another question I find quite interesting is to see how legitimate interest relates to issues, to other grounds which we see as legitimate interest. For instance, credits I saw as a separate legal ground for processing in Brazil, or health as a separate legal ground. I think those are typically things which we either would consider as legitimate interest and sometimes as public interest, but there's different issues. This as a starting point, I would say.
Thank you so much, Hilke, for your comments. And we're very happy to be able to make this connection with the new one of the new commissioners from Brazil. And indeed, hopefully, the club it will go even larger of independent privacy commissioners, and hopefully we'll get to see everyone at the next GPA meeting this year. You've mentioned some of the misconceptions and some of the difficulties of having this lawful ground put in practice in a lawful way. There was no discussion until now on the fact that who wants to put this lawful ground lawfully in practice will need to go through that balancing exercise that Miriam was mentioning earlier. And for this, I would like to go to Marcela, because she's actually advising clients in practice on how to go about that. We've talked a bit about the data protection impact assessment and the legitimate interest assessment. And indeed, for me, it's also interesting to hear that under the LGPD, there's the question of whether a DPIA is compulsory for or not for relying on this lawful ground for processing. And I'm curious to hear from you, Marcela, what's happening in practice with this balancing test. What are companies asking about, and what's your advice to properly put this assessment in practice? And just before that, please, if you have questions, if you are following us and have questions, write the questions in a comment, and we are happy to have a look and bring them here. Thank you.
So thank you so much, Gabriela, for the question. Indeed, you all mentioned that you find it very awkward that DPIA and LIA were a discussion. I mean, yeah, indeed, I personally like to think that it's like long past water under the bridge here in Brazil, and that now people understand that it makes no sense to require a DPIA for, you know, every case of legitimate interest use. It just doesn't make sense. But every once in a while, I do still hear that. And even from clients, sometimes clients ask, and they want to know what the difference between the LIA and the DPIA really is. So, I mean, I'm totally aligned with Bruno here. I think it doesn't make sense based on the law itself. And that is my advice all the time. Just, you know, you have to do the LIA, but you don't necessarily have to do the DPIA for every case of legitimate interest. And more so, maybe there are cases in which you have to do the DPIA which are not based on legitimate interest, right? There's this connection is not necessary. It can happen, but it's not necessary. So, you know, just briefly on that, because indeed, it may sound awkward for Europeans, but we do hear that a lot here. And then moving on to, great, so if we don't need a DPIA, we do need an LIA. And what exactly is an LIA? How you carry that out, right? I think Bruno, before writing the policy paper, Bruno had already written in his book, like a proposal for how to structure an LIA. And there's a lot of people that have been, you know, trying to put this out there and discuss models in which we could perhaps develop a good structure for an LIA. I personally think, and I've written about this, so I mean, I don't think there's an English translation, but maybe I should do that. One good way in which we could think about the LIA is bringing it closer to a proportionality test as we have it in constitutional law, right? I think in Europe, this is very common. I mean, people usually know what a proportionality test under constitutional law is, not necessarily in common law countries. But this idea stems from basically two facts. The first is that proportionality tests in constitutional law are much more common in Brazil, so it's not something entirely foreign to us. It's something that when someone says what it is, you at least have some idea. Though I like to defend that you should not use proportionality as just a word. You should use the real proportionality test. And I personally, and that has a lot to do with, you know, my previous experience, like to use the model that in Brazil became famous, perhaps by the hands of Professor Virgílio Afonso da Silva, who studied with Professor Robert Alexi in Germany at the University of Kiel. So it's a very structured way of doing it. And it has 3 steps. So first you have adequacy, then you have necessity, and then you have strict proportionality or balancing, if you prefer. And those steps, one of the main things to say is you don't go to the next step if you failed on the first step, right? So you only go through if you fulfill the criteria, right? And trying to be very brief here, the idea of adequacy in this context is what I am trying to reach through this processing really going to be reached through this processing? So is this adequate to do what I want to do? Because awkwardly enough, sometimes the answer is no. So you really should ask that question. Is this going to reach the objective that I wanted to reach? And if it doesn't, then, well, you stop there and you go look for something else, right? The necessity step is comparative, right? So once you know that what you're trying to do is able to reach what you want, then you should ask, is there a way of doing this same thing and, you know, damaging or impacting less the data subject? But what is important here is that usually the answer to that question will be yes. So, in fact, you have to understand that necessity is not only asking, is there another possible way of doing that? You have to ask, is there another way of doing that that is equally effective? Because there likely are many other ways of doing that, and if you don't add that secondary step, you don't really understand what the question is about, right? I know that usually, for example, Bruno argues that we should in this step think about whether or not there are other legal bases available that could be used instead of legitimate interest. But my reason for thinking that doesn't really make a lot of sense is precisely what Miriam and Hilke and Lara and everyone mentioned earlier, which is there's not really a hierarchy between legal bases, right? So why should I prefer to use another legal basis instead of legitimate interest, right? I mean, so long as you do what you have to do, I don't think this problem really is a problem. Which is why I usually don't think this is a necessary step to be carried out by companies or processors. And lastly, you have balancing itself, right? So it's in this last part in which you have already answered those two initial questions, in which you're going to see, okay, how exactly does this affect the individual? Here's also where you look at mitigation strategies, right? So what can I do to effectively, you know, minimize that impact? And that can be a condition for you to effectively approve your balancing exercise. So, okay, this is not balanced, but if I put this mitigation strategies in place, then indeed I have a really good justification for doing it. So of course, this last step is the one that is more open-ended and that has a lot of issues that have to be taken into account. But personally, I have been suggesting this 3-step approach because I think the 2 first steps, though they are much simpler, they actually are very effective in taking a lot of things out of the way. So when you get to balancing, you are actually able to carry it out more, you know, more properly. So very basically, that is the approach that I have been suggesting. I would once again like to highlight that I think this effort by the data privacy Brazil team is very important. There's a lot of misconception about legitimate interest out there, really a lot. So it's really good to have other models out there, and also to, you know, enable this kind of discussion so that we can also help the authority that will have to at some point look at this and say what they think, have more, you know, material for the discussion. Thank you.
Thank you so much, Marcela, for laying out the type of test you are suggesting. And I think this really highlights exactly the point you made right now, that guidance will be needed from the supervisory authority because different approaches can be developed in practice. And it's very important to understand and have this different approaches clearly laid out. So thank you for very much for that as well. I will go back to Bruno now, And you've mentioned that the report considers about 10 scenarios, at least from specific processing operations that you are considering in detail on whether they can rely or not on this lawful ground for processing. We've already heard from Lara, from Miriam earlier, that there are some processing operations which are clearly cut out for relying on legitimate interests. However, there are some scenarios that are not as clear. Some of them are very complex. It's not very clear whether you can rely on this lawful ground or not. Actually, also with a comment on what Marcela said earlier, that there's no hierarchy among the lawful grounds, and what is there a reason why not to always rely on lawful ground, on legitimate interests as a lawful ground? In the GDPR and under EU data protection law, we would say that you have to take into account the principle of fairness when you towards the data subject when you select the lawful ground, but that's obviously a discussion under the GDPR. We don't need to go into that now. Let's look at some of the more complex situations under that you're discussing in the report, and where it's not that clear whether you can rely lawfully or not on this ground.
Yes. So I think just to make a clarification, we totally agree that there is no hierarchy between the legal grounds and the legal base. This is clear from the structure of the text. But as Miriam just said, we are just in the beginning of building a culture of data protection, and there are many doubts and uncertainties here in Brazil. And one of them, and one of the misunderstanding here right now, is that like the legitimate interest is like the savior. So I'm going to rely all my data processing activities on legitimate interests. But no, there is a delicate dance. You have to take into account other 9 legal bases for that, because perhaps they might be easier to just justify on that. And also because by choosing a legitimate interest, it's like a complex argumentation. It's a complex reasoning. Even if the National Data Protection Authority considers that is obliged to conduct a LA. So it's easier for data controllers if that they can rely on other 8 legal bases. I'm not saying that it's always easier to rely on consent, because it's a complex journey as well. That's why in terms of being didactic, we call attention for that. Sometimes it's better to rely in another legal base than legitimate interest. Just to give a specific example, some data controllers are relying on legitimate interests, even if they are obliged to process data, because there is a legal obligation. So it's much easier to rely on that legal ground. That's why we call attention for that. By saying that, one thing that we could realize from our study and policy paper, and I think there is a rough consensus on that. Consent doesn't work in labor relations, because it's so hard to find out that it's going to be freely given consent. So in that scenario, a legitimate interest appears less complex than other areas. But as we have just pointed out in the report, there is also a misunderstanding on that kind of safeguard that should be put in place on that, because there is also this kind of misunderstanding. So if I'm not able to rely on consent, I'm going to legitimate interest, but you have to justify, you have to put this kind of balance complex equation on that. By saying that, I totally agree with what Hayok says, that fairness, it's a really normative issue that you should pay attention and articulate better with the notion of legitimate interest. By saying that, I think that it's challenging, or at least it's very complex to use legitimate interest when we are talking about automated decision making, about behavioral advertising, and so on. Because once we got in the third phase of LAI, the legitimate expectations become a more complex story to tell, and it's more complex to strike a balance between them. I'm not saying that legitimate interest is not going to work on that, but I'm saying that it's going to be more complex to find out for that.
Thank you, Bruno. Indeed, we are hearing a lot of conceptual and normative sort of debates around the concept, and then in-house counsel and outside counsel have to actually implement that in practice. So I will turn to Lara now, and as I was mentioning at the beginning of the conversation, Lara has to implement compliance programs in 80, 90 jurisdictions. Lara, how are you doing this in practice? What are some of the key challenges, the key differences that you're seeing when you are implementing the GDPR, the LGPD, and some of the other regimes that you think are relevant for this discussion?
I have to unmute first. Now it's a VC. So look, I think the most important thing that you're going to want to do, and this to a certain extent divorces itself from any particular legal scheme you're dealing with. You need to understand what personal data you're collecting and what you're doing with it. And once you understand that, you can then start mapping it onto different legal frameworks and say, okay, under this framework, legitimate interest seems an appropriate basis, but under this framework, it's a consent exception that I fit under. And then you need to be able to explain to the relevant authority how your collection and use and retention period and your entire life cycle fits within those schema. But the most important thing is understanding what you're collecting, what you're doing with it. And I also, whether you want to think of it as fairness or the law of consumer expectations or reality-based decision-making, there's a filter that you need to put everything through. And I do like fairness. It's just, is this a right thing to do? Is this something that's going to resonate with the individuals whose data I am collecting and using? And when you go through that exercise, you're going to have roughly the same things in the same buckets. And let's come back to legitimate interest in particular. Not all expressions of what is legitimate interest are exactly the same. The laws are going to express it slightly differently. And so again, you're going to need to pivot as you are explaining how what you are doing is appropriate within the specific legal schema that you're addressing. How does it work? And so, for example, you are seeing countries pivot from a consent only to a consent plus exceptions to consent, and then consent plus exceptions to consent to legitimate interest approach. And if you've got your overarching design, you're going to be able to pivot with them. And just to give a couple of examples, Argentina and Paraguay right now, under their current draft laws, are introducing the concept of legitimate interest. And it looks similar to Brazil, and it looks similar to GDPR. But will it precisely map? We'll have to see when the law is in final. Singapore very recently made a shift and enacted legitimate interest as part of its law. And so that's an example of where you've got consent, exceptions to consent, and legitimate interest. The other thing that it's important to look at is whether a legitimate interest assessment, whether it's an impact assessment or even a DPIA, is required by the law under which you're working. And Hilke's point earlier about DPIA is really for a certain set of highly sensitive processing under the GDPR. And would that be appropriate under LGPD? No. A sort of more of a legitimate interest impact assessment would be appropriate. And so you're going to want to scale. And sometimes you're going to need to do it in advance because that's what the law requires, or other times if the supervisory authority or data protection authority reaches out and asks you for the assessment, you'll need to turn it over. But again, it comes back to having that overarching work that you've done, which is so crucial to accountability under any legal data protection scheme in the world. You have to explain what it is you're doing. And you want to think about, is it fair at the end of the day to the individuals whose data I'm using? And I hope that's helpful, but if there are small and medium businesses thinking about it, that's an approach I would also recommend. You don't have to be a big company to use this approach. Just think through what it is you're doing and be able to explain it.
That's wonderful advice, Lara. Thank you so much for your input, and thank you for bringing a bit of a larger comparative filter to this conversation. Hilke, you really sold us on the fairness point earlier, and you see that we are now all thinking about it. What are your thoughts about what you heard until now on bringing a proportionality test to the legitimate interest assessment? Since this round of questions, the second round of questions, is actually on concrete cases, if you would like to mention one of the most interesting cases you've seen from the Court of Justice or from your own practice at the Belgian Commission or from one of your colleagues, please tell us about it.
Yeah, that's a lot. I would start by saying fairness. And I think fairness is also the way explained by Lara. I think it also has to do a lot with common thinking.
We are hearing you with a bit of a difficulty.
Are you still there, by the way?
We can hear you. It was just a bit broken, but we can hear you well now. If you can.
I'm afraid my Wi-Fi at home is telling me that it's done. Common thinking, I think, is important. When you talk about case law, that was your question, I think, the two cases mentioned which we use for this three steps approach are the let's say the scholarly examples on how you should work as a company. It's easy to implement. I think you have three steps. You go from it step by step. There's a few general notions, for instance, that what you do must be real, not hypothetical. There's a necessity test in it, which is basically necessity. Proportionality is always it's a scholarly thing to ask. See that as a different thing, but it's closely linked. Necessary, and there is this balancing test all the time, and balancing between different interests, it's the most difficult thing we have to do. We have to do it all the time. It's also the thing which is always criticized, because balancing is by nature subjective. So we try to make it objective, which is not so relevant. But let's say when you talk about cases in which we work at the moment, we still deal with a lot with, for instance, the Google's right to be forgotten, and there you have to balance the legitimate interest of the company to, or in that case, a different legitimate interest, but a legitimate interest to have an all-functioning and not discriminatory search engine, versus this individual, right, who claims his individual interest is at stake, and that is so difficult to do. We do it all the time. We do it all constantly. When you want to read something of what we did as authority, we have one case on our website in English. We have two of them. This is Google case, but also case number 25/2020, which is on a dating site, and the dating site did something based on legitimate interest, namely collecting your contact data also from people who, if you became a member of this dating site, the site collected your contact data, even if you didn't have anything to do or didn't have anything ever had to do with this dating site. It's an thing where, let's say, in order to make this dating site work, and also to, and then they claim the legitimate interest is also that it's the interest of society that people have easily contact to each other. But in order to do that, then they also wanted to have access to data which are not data of people already member of the club, similar to WhatsApp, etc. does. But it is an interesting case which we try to develop it a little bit. I think time doesn't permit us, but when you want to do this really as a case study, then make it as a case study, and then you see how you have to act in practice. But the problem quite often is that data processing is put in place because it's useful for a company without thinking about the consequences, and then the consequences are thought of in a later stage and not in the beginning. So one of the most, but that's maybe then my final comment, things most difficult to put in place is things like DPIs or data protection by design kind of ideas, that you start by thinking about data protection. No one or companies quite often don't do that. Public authorities don't do that either. They have a deal, and then data protection comes in as a kind of side thing. They have to sort of condition, but it's not part of the main thinking. And I think that's the main problem. I think that's what also FPF and so on, all these NGOs can help a lot in making it better. That is a sort of conclusion.
Thank you so much, Hilke, for pointing us to this case. I think it really reflects one of Lara's points earlier about the expectations of data subjects. You know, when you're relying on this type of ground or not relying on it. So users, well, actually non-users of this website had their data being processed on legitimate interest, but they were not even aware that this would happen in that context. So I think that's a very very relevant example to what we've been just talking about. Marcela, as we are approaching the end, I wanted to ask you, what are you seeing in practice? We have about 6 months or so since the LGPD became applicable. What are some of the questions you are receiving from organizations that have to implement it? Some of the key challenges, the scenarios, the most problematic issues that they encounter. Is relying on this lawful ground one of them? How would you place it in the broader picture of making the LGPD effective?
Yeah, I think it absolutely is, Gabriela, though it's not obviously the only question, right? But largely speaking, I think we pivoted from a situation in which a lot of companies kind of like relied on consent for a lot of their treatments. And then they started to realize, especially once, the law came into force and we have more and more discussion about this, that maybe this is a really bad idea. Because, consent has to be freely given. You have to be able to, the data subject has to be able to say, I no longer want this. And then you have the data. And if it's entirely and absolutely essential for your business model, what are you going to do? So I think legitimate interest also came in line with that reasoning. So should I use legitimate interest for those scenarios in which I find that consent, which is where my mindset was before, doesn't really work, right? And then the challenge here, and I do believe that to some extent, that is a challenge for the community in Brazil in general, is having more discussions that are not just consent on the one side and legitimate interest on the other side, which are two of the legal bases that clients, companies, everyone asks the most. So, we have to be able to explain the other options as well, because as we were discussing here, there's no hierarchy. So companies should be able to know what's best for that specific treatment. But for sure, it comes in the mix of many questions that are very relevant now. Just to briefly comment, I think security incidents are something that has been, one of the main topics for the last months in Brazil. We've had a lot of security incidents as well, and effectively cases of a lot of data from a lot of individuals being leaked. So that became relevant as well. Companies trying to understand it a little bit better in terms of what exactly is a data security incident, because you can have an incident in which you don't necessarily have personal data, and then what the authority considers to be relevant risk or damage to individuals, because those are the cases that in Brazilian law you have to notify to the authority. And a bunch of other discussions. I mean, we could stay here forever for me to tell you the questions that we get. But I think those are some of the main topics. And for sure, I think companies are entirely aware now that this is relevant, and they're trying to adapt, which already is a really good sign.
That's wonderful to hear, Marcela, and thank you so much for sharing from that experience. And this also means that there's a lot of work to do, for FPF, for Data Privacy Brazil, for all of our friends in the US and in Europe as well, to bring more clarity and to discuss this. I'm so grateful for your time today, Bruno, Hilke, Marcela, and Lara. And I would also like to give a shout out to our friends from Data Privacy Brazil that helped with organizing this, to Mariana. Thank you so much, Mariana, and to Thais. It has been a great collaboration. And to wrap everything up, I would very much like to have Miriam back with us. Please, Miriam, if you are here. It was so lovely to hear from you. And you have the last word, the closing word.
Thank you very much, Gabriela. I had the honor of opening this discussion, and now I have the honor of closing it. And I'd like to say that it was a truly inspirational debate, and it was really interesting learning and hearing about all the different perspectives on this very complicated legal base, which is legitimate interest. So thank you once more. Congratulations for the publication of the report in English. I'm sure it's going to be a very relevant and important contribution to this debate, not only in Brazil, but possibly also in other countries as we move forward on interpreting and finding the right conditions for using this challenging legal ground for data processing. So thank you once more, once again. I do look forward to continue engaging with all of you.
Thank you.
Bye-bye.
Bye-bye.